Hey y'all, Eric here. Every time I get a computer update, my OBS studio goes haywire. My microphone goes away. My speakers go away. This time the camera went away. And in fact, I got up to check the connections, and when I came back, the picture still had my chair in the screen, even though I sat down in the chair and the camera was off. And I'm like, so I had to close it out and bring it back up. All right. So today, welcome back to my channel for LGBT History Moment. Today, being Thursday, October 30th, I am spotlighting today the Supreme Court case from 2015, 10 years ago, um, Obergefell versus Hodges, which was the case that states must issue and recognize same-sex marriage licenses. The reason I waited till today to honor that is because 1 week from today, actually, I'm sorry, 1 week from tomorrow, the Supreme Court will, actually, let me look at my calendar real quick. Sorry, just 1 second. I'm not going to pause. I need to look at my calendar to make sure. Yes, 1 week from tomorrow. On November 7th, the Supreme Court of the United States will decide if it will take up a Supreme Court case to overturn Obergefell v. Hodges. Now, before I dive into that piece, the Obergefell v. Hodges maintained, as I said, that states must issue and recognize same-sex marriage licenses establishing marriage equality as a fundamental right under the 14th Amendment. The landmark decision made by razor-thin margin, 5-4 vote, invalidated all state-level same-sex marriage bans and required all 50 states to perform and recognize same-sex marriages on equal terms with heterosexual marriages. The legal basis for this is that the court found that the fundamental right to marry is guaranteed to all Americans, including same-sex couples, through the due process and equal protection clauses of the 14th Amendment. The highway for this, if you will, was also based on the landmark case of Loving versus Virginia, which also found that it was unconstitutional to deny marriages between races, which allowed a black and white people to marry, and essentially anyone can get married. And with that information, the interracial marriage ban was struck down, and then interracial gay marriage was struck down, and then the gay marriage ban was struck down. And so that happened 10 years ago. Now, what is happening next week is the court case that's being brought up, and I'm going to bring the camera over here just to remind you, what started this all sorry, I had to close my door. One of the housemates is back. What started this all was Kim Davis. That's whose picture you see. And she's the one who, in her state, when a gay couple came in to get their marriage license, she refused to issue it on the basis of her religion. even though she works for the county and the county is subject to the state rules, and then, of course, subject to federal laws. And again, I'll remind you that the United States is a constitutional republic type of democracy, not a theocracy. And so she actually lost her job because of this. And then the new county clerk started issuing marriage licenses. Well, before she filed this case, Justice Thomas Clarence had made an announcement earlier in the year, and we all saw it coming. It cannot be a surprise that he said that the gay marriage law could be overturned. And in fact, he said that he was going to try to do it. Then I issued the same thing, saying that if gay marriage is overturned, because my standpoint, let me just bring my camera back over so you can see me. My point of view is that when I was born 63 and a half years ago, I was born an American, which means that came with all the inalienable rights given to me by the Constitution. However, at the time that I was born, interracial marriage was illegal. And my family, on both my mother's side and my father's side, were interracially mixed, which means my parents were children of that, meaning that I became a second generation born of that. And so the country looked at me and looked at all of these marriages as being invalid, even though there were state marriage licenses issued. Until the 1970s, when Loving versus Virginia struck that down. Well, when that was struck down, that then became the basis for the future Obergefell v. Hodges to validate same-sex marriage. Well, Kim Davis hasn't let this go. She wants same-sex marriage overturned, and she has a justice to support her. So next Friday, the Supreme Court will issue the decision whether they will actually take up this case. I'm not expecting them to turn it down. I'm expecting them to take it up. Which brings me to an announcement that was made. I didn't see this announcement, but it was made a few days ago, that in the state of Texas, and this was reported, and I got this information from a website called Them. It's a newsletter, it's politics, and I'll link this into the description of the video. But there is a new Texas rule now that allows judges to stop marrying same-sex couples based on religious objections. And this was posted by Samantha Rydell yesterday on October the 29th. Judges in Texas, here, let me bring this up. You can see it along with me. But like I said, I'll link this into the video. Judges in Texas may refuse to marry same-sex couples if doing so would violate their, quote, sincerely held religious beliefs, unquote, according to a new judicial rule quietly enacted by the Texas State Supreme Court last week. On October 24th, the High Court issued an order modifying the Texas Code of Judicial Conduct, which lays out rules for judges in the state. The code states that a judge's extrajudicial activities should not cast reasonable doubt on the judge's capacity to act impartially as a judge. Really. But the court's newly adopted comment creates an exception to that rule, specifically for marriage rights, stating that, quote, it is not a violation of these canons for a judge to publicly refrain from performing a wedding ceremony based upon a sincere held religious belief, unquote. The comment effectively protects Texas judges from official sanctions if they say their religion prohibits them from marrying a same-sex couple. Excuse me, but a judge hands down decisions based on the law. Again, for the purposes of this video and the conversation, the United States and all of its states and territories are under the umbrella of a constitutional republic, not a theocracy. Now, having said that, let's set that aside for a minute, and we will just talk about individual freedoms of religion. You know, this country was founded on freedom of religion from the king tyrant of England. Now, I'm all for that. But gay marriage has nothing to do with religion. It does not, unless someone wants to get married under a religious umbrella. That's the only time that it comes in play. But even heterosexual marriage is not necessarily done under a religious thing, because even at the end of the ceremony, no oath is given other than people saying their vows. But no one is saying, do you so help you God? You know, I've taken oaths before. As a commissioned notary public, I had to take an oath. Marriage ceremonies do not include that. They don't. It's a promise, but it's not an oath. And it's certainly not a religious oath. And so for Texas, and I would suspect, given the makeup of the North Carolina Supreme Court, if they were to take this up, they may do the same thing in North Carolina, allowing judges to object to marrying a same-sex couple due to their sincerely held religious objections. Which brings me to the overall point that, again, more receipts that the LGBTQ Americans are under attack in their own country. Actually, let me amend that. In our own country. Now, I'm not married. I'm not. Effectively, you could say that when I came out to myself and came out to people as being gay, that I might have lost my right to marry, which even then I was defiant. No, I didn't. Now, at the time, nobody would marry me if I wanted to. But I would have stood on the fact that as an American, I had the right to marry. Now, there's a possibility that my right, because I'm not married, that I may not be able to marry in the future if Obergefell v. Hodges is struck down. Essentially, what they're saying is the Supreme Court may not undo current same-sex marriages, but they would effectively block future same-sex marriages. I don't know. I'm pretty sure that states will probably try to find a way around that. But I have always said that I would go try to find a lawyer who would be wanting to make a name for themselves, but who is smart on constitutional law, to find a way to undo Loving v. Hodges. If Obergefell v. Hodges is undone, that I want Loving v. Hodges undone. And here's why. Justice Clarence Thomas is married to a white woman. He is able to be married to that white woman because of Loving v. Hodges. Mitch McConnell, who is not running for re-election, he is married to an Asian woman, and he was able to marry his Asian wife because of Loving v. Hodges. And J.D. Vance, the Vice President of the United States, is married to a woman of Indian descent. If I can get, or anybody can get, Loving v. Hodges overturned, their marriages will be null and void, just like my future marriage. It's only fair, right? I can't get married, then you shouldn't be able to get married. Now, I could assign distractionary tactics to this issue, because we have bigger fish to fry. 42 million people are set to lose their EBT benefits come Saturday, November 1st. That is a much bigger fish to fry than this. People on the Affordable Care Act, whose insurance enrollment period starts Saturday, November 1st, will see on January 1st their premiums exponentially going up. If you don't follow her now, please go to YouTube and search Politics Girl. She has a short where she talks about her journey and her family's journey on the Affordable Care Act. And they have received the plans for next year, and these premiums are without the COVID era subsidies. She disclosed that her family, I believe it's a family of 4, and she has pre-existing conditions herself. Her monthly premium, if they stay on the same plan, is going to be over $4,000 a month. And she has said flatly that is not sustainable. And what she's saying is she is telling people, she was telling her family, we are not going to bankrupt ourselves just because of my health issues. She's actually telling her husband and her children to find an insurance plan that they can be on and leave her off. That is ludicrous. Ludicrous. Because of a $4,000 a month premium. And that millions of people are going to lose their insurance entirely, not only because they won't be able to afford the insurance premium, but for those who are on Medicaid, they're going to lose their insurance as well. And because I took early retirement, and my Social Security benefits are not enough for me to even qualify for the Affordable Care Act, I'm actually on my state's Medicaid roll. That's how I have insurance, which is cool because I'm also a type 2 diabetic. I'm trying to reverse my insulin resistance. And so far, I'm winning that war because my number last Friday came back in at 5.3. So on paper, I am no longer diabetic. But that is a fallacy, because if I go back to my old habits, I will be diabetic again, and that ain't happening. And so my point is, there are bigger fish to fry. There are. Yet we have people trying to undo our rights. Undo our rights. You can see in this video, I'm an African American guy. My voting rights are under attack. Here in North Carolina, they're redistricting this under orders from the president to try to save the power in the House because they're afraid. They say the only reason they're doing this because they're afraid, yet they're saying that they're doing this because of California. California is doing it because of Texas. Texas started this crap. And again, with the judges giving them a way out from doing the marriages because of a religious objection, Texas I'm just shaking my head. I'm just shaking my head. And then on top of that, we've now got federal workers who have lost their job and other federal workers who are deemed essential workers who have to go to work who are not getting paid. Military personnel with military people overseas or who are on duty, their families not getting the money. Not getting the money. And the Republicans can't beat their chests loud enough to blame it on the Democrats. Now, I will say this, and they can take this blurb if they want to, I don't care. There are some people in Democratic leadership that actually need to be slapped across the face because they waited till now to start talking about the Affordable Care Act, the health care subsidies, when they had the chance to do something about this earlier in the summer. And I will say this, Mike Johnson, the Speaker of the House, is a punk. He is. He's a punk. He is actually keeping the House from being in Washington for two reasons. Number one, if the House is in session, he has to issue the oath to, actually, let me just look this up because I can never remember her name. I'm going to butcher this name. Her name is Adelita Grijalva. She's a Democrat who won a special election in Arizona's 7th Congressional District, September 23rd, over a month ago. And she has not been given her oath of office. Mike Johnson refuses to swear her in. Now, his excuse is that, well, the government is shut down. I'm happy to issue her oath when the government opens up. No. The reason he's not giving her that oath is because she will then be the 218th vote needed to call for a vote to release the Epstein files. Yep. If the Republicans who voted for this as well hold true, she will be the 18th, which means a majority of the House members, a simple majority, can call for the release of the at least vote for the release of the Epstein files. And he's doing his level best to stop that from happening. Because number one, if he doesn't, Trump will cause him to lose his job. And number two, and we can't have that because in the line of succession, he's third in line for the presidency if something were to happen to Trump and Vance. But I say all this to say is that while gay Americans, LGBTQ Americans, have to focus on SNAP benefits if that is affecting them, WIC benefits if that affects them, the Affordable Care Act if that affects them, if they're federal workers and that affects them. For some people it can be too much. Some people it can be too much. Yet they're playing gamesmanship with people's lives. You know, Sarah Palin said something about death panels back in the day if the Affordable Care Act would be put in place. Well, the Affordable Care Act is not setting up death panels. The Trump administration is. That's all I'm going to say about that. So as we contemplate the right to marry, keep this in mind. Elections have consequences. Not just on the federal level either, as we see by way of the state of Texas. So it's the state level, the county level, and the city level. Elections have consequences. But, as you've seen through some of my other videos, resistance is not futile. Take care. If you're in the Charlotte region, please get out and vote. Early voting is open now through Saturday at 3 o'clock. And then the next time you'll be able to vote is Tuesday, November the 4th. If you're in an unincorporated area, doesn't matter. We still have, because I do, we still have 2 items to vote. Our school board position, which is where I live, District 2, and the 1% sales tax referendum. If you live in an unincorporated area, is to your benefit to vote for this because it has money in it for neighborhoods such as ours that are not serviced by the county, and of course we're not annexed by the city. There is money for those neighborhoods for their roads, and some of us, including mine, desperately need it. So take care, and I will see you tomorrow for the last video regarding LGBT history. Take care.